what case is first today?
We're ready on Hurd. He's on Polycom.
HURD. Files.
Yes.
Right, so we're on the record in docket 2401-836 and 2401-835. I'm sorry, 2401-305 and 2401-836. That is people of the state of Michigan versus Eric Hurd. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Austin.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Hurd. He's present with us remotely from the Ingham County Jail.
And sir, you are Eric Hurd Jr.?
Correct.
Thank you. This is the time set for I have this as a competency hearing or review, a competency hearing. Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe myself and Mr. Austin are in receipt of the opinion of the Forensic Center on the matter, in which they determined that Mr. Hurd is currently incompetent, but has a strong likelihood of being restored within the statutory time period. My understanding is this is going to be a stipulation to the findings, and I believe Mr. Austin has an order prepared for the court.
All right. I have two orders prepared. All right. So is that your understanding, Mr. Austin?
Yes, that is correct, Your Honor. I'm in receipt of the Forensic Center's opinion. I am in agreement with it, and I would ask the court adopt its findings that Mr. Hurd is currently incompetent, but is likely to be restored.
All right. And I'm in receipt of the report, and if I haven't had the opportunity to review the report with the pursuant to the stipulation, we will stipulate to the report and the findings of the report.
I do have some proposed orders at the court.
And I do too.
Okay.
So I've got an order, and I'll let you review them. So just to make sure we have the same, I have both orders on one on each file. So one on 2401-836 and one on 2401-305, where the defendant is incompetent to stand trial but restorable. There's a substantial probability the defendant, if provided a course of treatment, will attain competence to stand trial within the time established by the law. The defendant shall undergo treatment to render the defendant competent to stand trial. And then there's an A, B, and C. Is that the same order?
That is the same one that I have, Your Honor. That is the second box that is check marked.
Right. Box number 2. Do we have a plan now for the restoration? Does CMH have a plan?
I don't recall seeing one in the report. I think they determine that once they get the order, if I'm understanding.
Right.
Yeah.
That would make sense.
I believe that is correct as well, Your Honor.
All right.
How it happens.
So my take on this is to set it for some time in the future, just so we don't lose track of it. Yeah.
60 days for a review.
60 to 90.
Yeah.
All right.
90 might be better.
All right. So I'm going to sign the 2401-305. I'm going to sign that order. 8/2/2024. We'll get a new date for that file, but let me do both here. And then I'm going to sign 2401-836. And then let's get a date. I'd say probably 90 days out.
November 7th.
November 7th at 8:30. All right, I've signed both orders that the defendant is presently incompetent but restorable within a time prescribed by statute. And we have reset it for review on November 7th at 8:30, both matters. Anything else for the record in docket 24-01836 or 24-01305, Ms. Wilson?
Not for the people. Thank
Mr.
you.
Austin.
Nothing conditional on behalf of Mr. Hurd, Your Honor. Thank
All
you.
right, and then you can get a copy of the orders for your file if you choose. They'll be signed.
Yes, please. Thank you.
Thank you.
So you're paying.
So thank you, Mr. Austin. So you're all set, Mr. Hurd. Thank you for your appearance today. Twenty-four 02093. That is People of the State of Michigan versus Cedric Boyd. The parties please introduce themselves for the record. Ms. Wilson.
Abigail Wilson for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Boyd, who is present and is currently standing to my right.
And sir, you are Cedric Boyd, is that correct? Thank you. This time set, I have set for a preliminary examination, and then there's a PA 53 violation.
I do see a contempt hearing on the docket. I have not received anything about what that is.
All right.
I'm guessing it's just like not checking into pretrial services.
Oh, I
or
think it's the
something.
tether because he wasn't get the money. Maybe.
The tether was, yeah, it's the tether.
Yeah, and he actually, Mr. Boyd brought with him today the and he's been in communication with me. He has the documentation now to send to get the indigent tether. He just hadn't had a chance because he literally just got it yesterday, I think, the documents
All right.
to give to them.
I have pursuant to that, and we'll talk about that, but Ms. Schroeder, Abby, you did indicate that the defendant had not reported pretrial services and his tether shut off due to non-compliance. It appears that so the bond violation was for the tether
Sorry,
and for failing to enroll to pretrial services.
I think I said it was, I was guessing it was not reporting to pretrial services.
Okay,
I believe he has. That's how he got the tether.
Yes.
all right.
Yeah. So I think it's just the tether.
Yes, and he is, if the tether is to remain on, he has the means to resolve.
All
that
right,
issue.
all right. And that was July 19th, so that was written at least a couple weeks ago.
Yes. and-
All right. I have it set for both hearings, both the PA 53 and the preliminary examination. How are we proceeding on the preliminary examination?
Thank you, Your Honor. It's my understanding that this is going to be a plea to an added count 5 of assault or assault and battery pursuant to 750.81. That's a 93-day misdemeanor and or 500. The people have no objection to YTA status should the defendant be eligible. And there is an agreement to forfeiture of all weapons and ammunition that may have been seized during this incident by the police.
Right, so we have a kilo brew.
Yeah, so
Oh, you did say that. Okay.
I don't think I did say, but there's also a Killebrew no front jail.
Okay, Killebrew no front jail. There's no objection to YTA if eligible. And then forfeiture of all weapons and or ammo involved in file. So this is the added an amended or it's amended count 5.
It could be an amended, I think it would be an amended count. I think it was 4, is that
All
the,
right.
no, amended count 3, or it could be an added count 5. I personally think an added count 5.
I think
is
added
cleaner.
count 5 makes more sense.
Yeah, I do too. All right, so we'll add it account 5 of assault and battery. That's a 93-day and or.
$500.
All right. And with a plea and successful sentencing on count 5, counts 1 through 4 to be dismissed. Is that-
Yes, that's correct, Your Honor.
Right, and Ms. Schroeder, is that your understanding of the plea agreement?
It is, Your Honor.
All right. May I inquire of your client, Mr. Boyd, of his advice of rights concerning the misdemeanor plea?
Yes, Your Honor.
All right. So, Mr. Boyd, you have the following rights in this matter. I'm going to walk you through those rights, all right? You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented by Attorney Aaron Schroeder today. Should be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You understand that, sir? You have the right to have the court ordering witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'll also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty instead. Is it your wish and intent today to plead guilty to the count 5, the added count 5 of assault and battery? All right. All right. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury? Is that a yes, sir? All right. Thank you. All right. I'm going to bring your attention back to July 12th of 2024 at the offense location of 4314 South Martin Luther King, City of Lansing, Ingham County. Were you on South Martin Luther King in the City of Lansing on July 12th, 2024? Okay. And at that time, the accusation for count 5 is the assault and battery. I'm assuming it's the Kyrie Montgomery victim.
That's correct, Your Honor, yes.
It is alleged that you offensively touched Kyrie Montgomery in a way that was not in self-defense, all right? That it was not in the self-defense of your person. So why don't you tell me, or Ms. Schroeder, you can ask questions concerning the factual basis.
If I may, Your Honor.
Yes.
Thank you. Mr. Boyd, on the, just trying to show you my pen up here. There we go. On the date of July 12th, 2024, were you with Kyrie? Is that how you say his name?
Is that a yes?
Yes.
Yes. Yeah, he pulled up on you and the two of you got into it. And what do you mean, when I say got into it, what does that mean to you?
We just don't like to argue.
Were there threats being made to each other?
I'm gonna have you move the mic.
Yeah. So when you say threats being made to each other, what do you, what, were you raising hands? Were you?
No, I'm just speaking words like, just that. But
Okay. But you two were close to each other, you could have followed through on it if you'd wanted to. And you made your statements with the idea of putting him in fear of some type of immediate, like you were gonna punch him or shove him or hit him. And that was, and that was something you intended to do, correct?
No.
Oh, you intended to put him in fear. Okay.
And none of this was done in self-defense, is that correct? Anything towards a factual basis for placing the victim in fear of some type of an assault, Ms. Wilson?
I just want to clarify, because I just want to clarify, so, you're saying that it was not in self-defense, correct?
Well, no, I mean, no.
It was not, you weren't doing it to defend yourself. You were just in a fight, you were upset at him.
Okay, and you understand by playing here today, you're giving up any right to self-defense?
No,
You do not understand that?
I don't understand what you're saying. That's what I'm saying.
Okay,
So Ms. Schroeder, if you want a second to explain it to him?
if I may, Your Honor, I can just do that right now.
All right.
Self-defense is the idea that you can defend yourself against somebody,
Oh, yeah.
but you weren't acting in self-defense. You and him were having a fight already. Is that correct?
Right.
Right? So it was not in self-defense. The two of you just had an argument because you've been arguing all day.
Yeah.
Okay.
I think that's sufficient, Your Honor.
All
Thank you.
right. I find the factual basis to be knowing, voluntarily, and accurately made. It appears Mr. Boyd understands that self-defense may be a defense in the matter. This was stemming from an argument in that he was acting to put the victim in fear, Mr. Washington in fear, and not in self-defense.
Montgomery, Your Honor, is the last name of the victim.
Mr. It's Kyrie Washington. Kyrie Montgomery.
Montgomery, correct, yes.
Anything towards the factual basis now, Ms. Wilson?
No, Your Honor, thank you.
Ms. Schroeder?
No, Your Honor, thank you.
All right. I find the factual basis to be knowing, voluntarily, and accurately made. And we're going to refer to probation. So, Mr. Boyd, you should go down to the 5th floor and they're going to make an appointment for it with you and be candid with them. Just tell them what happened. And they're going to prepare a report for me. And then at sentencing date, we'll see what options are available for sentencing. Okay. All right. There is a Killebrew agreement, a no upfront jail. There's no objection to YTA, and that all weapons are to be forfeited. If I was not going to follow that Killebrew agreement, that's the agreement between the two lawyers, you'd have the opportunity to withdraw your plea. Do you understand that, sir? Is that yes? If I don't follow the Killebrew no upfront jail, you can withdraw your plea.
May I, Your Honor?
Yes.
It's the agreement we talked about yesterday that if the judge were sentencing to decide, no, I want to give you jail time. That's not the agreement we made today with the prosecutor. So at that point, you could say, no, I want to withdraw my guilty plea and start the process over.
Oh,
Yeah, okay.
Okay. You understand that, sir? All right. Thank you. All right. So we'll refer to probation and set for sentencing on
September 26th.
September 26th at 8:30. So we'll see what options are available to us on September 26th at 8:30. Make sure you stop by probation, okay?
Here's your.
All right. Anything else for the record in 24-02093? And Ms. Wilson, what did you want to do on the PA 53?
Do you have a means to get down to JSG?
I mean, if we're gonna keep the tether on until sentencing, I have no problem with holding it in advance, and if he can get the documentation to JSG, then we can just dismiss at sentencing.
All right. Do you have any comment on that, Ms. Schroeder?
No, Your Honor, I think of course, Mr. Boyd, I think would appreciate having the tether off, but I think at this time, given the fact that we do have the outstanding violation for not having it on, even though he is going to fix it today, I just confirmed that with him. He has the means to go to JSG today to get that matter fixed. I would ask the court maybe give him to sometime next week to make sure it gets done.
All right. So let's address it at sentencing.
That's where.
We'll look at this
yeah.
at sentencing. Mr. Boyd, just keep doing what you're doing, but what you've got to do is get that tether on. All right.
He has it on.
Okay. All right. So as long as it's working functionally, because they're going to ask about it in probation. I know they're going to ask about it.
And just for the clear to the record, Your Honor, not that I apologize for interrupting the court a moment ago.
You're fine.
He does have the tether on. The issue is because he had not been able to get the indigency paperwork to them, they had shut it off.
Right.
And so now he has the paperwork showing he's on Medicaid receiving food assistance. He just needs to get down there to show it to them.
All right. We'll hold the PA 53 in abeyance until sentencing, do the pre-sentence report, and then we'll see what options are available at sentencing. All right, sir. All right, that's all for the record in 24-02093. Thank you, everybody, for your appearance.
Thank you, Your
Thank
Honor.
you, Your Honor.
Real quick.
All right, Miss Wilson, what are we doing? What case are we calling next?
Oh,
I'm
pardon,
the only attorney.
Yes.
Mr. Carter, you're kind of default here. What case are you on, Mr. Carter?
Clifton Thomas.
Is my appearance not in there?
I have Mr. Milk still on the file.
Mr. Carter like just filed a substitution,
All right,
so it might have not made its way to the court file yet.
all right.
Thought I got an email with your signature on it.
I saw, yeah.
Yeah, I think you might have, it just hasn't caught up to the file. Because I have a substitution of counsel in the file, so, and it's signed by me, so you should be good. All right, so we're on the record in docket 22-00125. That's people of the state of Michigan versus Clifton Thomas. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Carter.
May it please the court, David B. Carter Jr. on behalf of Mr. Clifton Thomas, who is present and standing at council table.
And sir, you are Clifton Thomas, is that correct? All right, thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. As indicated before we called the case, Mr. Carter just was appointed to this matter. So I believe we're going to be requesting either a good cause adjournment or a waiver of the 21 days in order for Mr. Carter to get caught up on discovery.
And is that a fair statement, Mr. Carter?
It is, Your Honor. I guess this case had some issues with finding conflict counsel. They reached out to me and I indicated that I would take that. I did have contact with Mr. Thomas. I did indicate to him that he had a 21-day rule, which indicated that his preliminary exam would be within 21 days of the date of his arraignment. I explained to him that if I were to take the case and represent him from this point on, I'd be asking him to waive that 21-day rule so that I could be more fully prepared to represent him at all stages of the proceeding. He has agreed to waive that 21 days, and if you'd like to inquire.
Right.
You may.
Thank you. So Mr. Thomas, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney David Carter Jr., and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish not to waive your right to a prelim in general, just to waive your right to a prelim within that 21-day period, within that framework. And so that is Mr. Carter can get discovery and zealously represent you in your defense.
Yes,
is it your wish today to waive your right to a prelim within the 21-day period? And Ms. Wilson, the people also waive the right to a prelim within 21 days.
We do, Your Honor. Thank you.
I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will reset this prelim. And it's easier for us to get dates and then to check your schedule, Mr. Carter. So try August 22nd at 8:30.
I am in Eaton County on 2 different cases that morning.
All right, let's try another one. August 30th at 8:30.
I'm in a trial that day.
That's nice.
September 5th at 8.
September 5th.
I will take that.
All right. All right, so we'll set it for September 5th, I'm sorry, September 5th at 8:30. So Mr. Thomas, please keep in contact with your attorney, Mr. Carter. We've reset this preliminary examination for September 5th at 8:30. All right, sir?
Yes, sir.
All right, anything else for the record in dockets 22-00125, Ms. Wilson?
Top of the people. Thank you.
Mr. Carter, anything else?
It's just that I will let the prosecutor know within a reasonable time if in fact we don't need that.
All right.
exam.
Thank you.
Appreciate it. Thank you.
Thank you.
Thank you.
Aaron, are you still on
Thank you, Mr. Carter.
Boyd's other case? Do you want to do his motion here? Yeah. We have Mr. Lavoy, we're motioning for his other file to be brought over to this court.
Is that? Oh, Mr. Lavoy's here by Polycom.
Yes.
I did not. I just left.
And so is this the one? This was Judge Ward's file, right?
Correct.
There's yeah, there's a,
I don't think she reviewed it.
let's see. All right.
Yeah.
So we're on the record in docket 24-02037. That is People of the State of Michigan versus Christopher Lavoy. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Aaron
Right.
Robinson, Assistant Public Defender for Mr. Lavoy.
And sir, you are Christopher Lavoy, is that correct?
Yes.
Thank you. All right, this is the time set for a motion hearing. It's been brought to my attention, we have several matters in front of the court that that have been, and pursuant to, we started a preliminary examination. I'll go through the history of the case. We started the preliminary examinations, two preliminary examinations. At that time, Mr. Lavoy was going to represent himself. We placed Ms. Robinson as standby counsel. Then there was a second, the one prelim was bound over. I'm not certain,
I don't
or
believe,
neither.
I don't believe either of them have been bound over yet. I believe he decided he wanted to petition for competency at the
Correct.
last one. And then while he was out on bond, he picked up a new file that was assigned to Judge Ward. Now there's been a petition filed for competency, and just for judicial economy, we're asking for the case that was assigned to Judge Ward to be brought over to this court, just so we have everything together. The court has two of his felony files and a couple of misdemeanor files with him as well.
That's my understanding. I am in possession of Judge Ward's file with the petition, and for the record, Ms. Robinson did assist in getting the petition all set. But this puts all the files in this court.
That's correct.
And we made this proposition to Judge Ward, and Judge Ford gave us the order. So is there any objection to the court taking over 24-02037, Ms. Robinson?
No, Your Honor.
All right. So all the files will be in front of this court. I will sign the order for competency examination that goes along with the petition on the two others. So all the files have the petition, and we placed it all on the record just because my understanding is part of the process. All right, that's part of the process. So that understanding, all the files are with this court, and all the petitions are with this court, and then we will await a review date or some type of report to be done by the Forensic Center, but that cleans it up a little bit. Have we reset those other files, or because we should just put this all together?
They'll do it.
All right, all right.
Once they send it to forensic.
So the motion is granted to consolidate. With this court. And then they will set the next date. But have we set the other two files, or we're just awaiting?
Waiting for them to all get together.
Let's look at I just don't want it to fall through the cracks. We got three files. We have a petition that's, and I hate to adjourn anything without a date.
Yeah.
That's my fear. So let's go ahead and.
I have that it's set for 9/26 at 8:30 for one of his
On
cases.
one of these files.
That might be for
That
the
was Judge
continued.
Ward's.
Oh, okay. So
Yeah,
that was taken
that's
off.
what's taking me a second. I gotta find everything to be able to reset it, otherwise they're gonna lose it.
So whatever we do, let's do it on everything.
Yeah.
Yeah.
And I
It
think
was
we were gonna
reset
set his
for the-
misdemeanor files with everything as well.
Yeah,
Yeah.
so we're just making, Mr. Lavoy, we're just making sure that all the files are in the same court and that we've set your date on all the files for the same, so you don't have any files outside of that at this point.
Correct. But it was reset for the 22nd.
Yeah, that was the date, but that was in a different court. That was in Judge Ward's court. So we're gonna find a new date to put them all together in this court.
That was, the date that was reset for this court. It was August 22nd.
Correct, that's correct, sir.
November 7th.
So we'll set a control date. And this is, Mr. Lavoy, what we're doing is we're setting it all on one, and we got to wait for the petition to be, an evaluation to be done, since you filed a petition for competency. And so we're setting all the files at the same time to make sure that we don't lose track of any files and to make sure that they're timely in getting the report done. All right, sir?
Yes, sir.
So we'll set it for November 7th at
8:30.
8:30. We're gonna put all the files on that date. All right, is there anything else for the record in 2402-037, Ms. Wilson?
Not for the people, thank you.
Ms. Robbins?
No, Your Honor,
And I know you're standby counsel. So,
not on this file.
oh, not on this file. All right. All right. So, Mr. Lavoy, we've set this for all the files, and we'll wait for a report from the Center for Forensic Evaluation. All right, sir?
Yes, sir.
All right, we're all set. Thank you for your appearance today.
You ready? Books and Henton?
I am right now, Henton.
Henton, okay.
So,
Oh, that's right, yeah. So if we want to bring up Henton, that's just gonna be a waiver, I understand.
all right, so we'll bring up Henton.
Oh, yeah. he's outside.
And I saw Mr. Milks here
Yeah,
briefly.
he was, and then he left.
He left with the client.
Oh. Is Tuyashimi going to be on Polycom today, or is he?
He's not in custody.
Oh, he's not in custody. Oh,
I have Henton in custody, and then that's the last one this morning.
I'll be here all day, so. Yeah. Yeah, I know you're not. See you pop up with my phone, and I'm like, oh my God, Steve, what do you want?
Much rather just tell us either way.
I know. I like things in writing personally, but.
I mean, I don't mind putting it in writing, but usually if I tell you something, I'm good with my words.
So far.
I'm never not gonna be.
Mine never has to do with the fact that you're not good for your word. It has to do with the fact that my memory is insufficient.
That too,
Fair
yeah,
enough.
correct.
See, I'm not, see, my memory's like my saving grace. Maybe
at 2402-122. That's people of the state of Michigan versus Jadavian or Jadavian. You're gonna have to correct my pronunciation. Jadavian Embry. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Mills.
Good morning, Your Honor. Stephen Milks on behalf of Jatavian Embry, who is currently present and standing to my right.
Sir, you are Jatavian Embry, is that correct? Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. This matter was scheduled for preliminary exam today. In consultation with Mr. Milks and the complaining witness in this matter's attorney, Mr. Sturdivant. Yes, there appears to be some possible Fifth Amendment issues with some testimony today that we need to flesh out. So I think at this point, we're going to be requesting a good cause adjournment to do, I think it's like an actual Fifth Amendment hearing about what privileges might be in existence and what might not be.
All right, so I'm assuming Mr. Sturdivant, you can make your appearance for the record.
Thank you, Your Honor. Daniel Sturdivant, number 82936. I represent the alleged victim in this matter on a unrelated, well, it's a related criminal matter.
All right, so my understanding is there needs to be a hearing so we can indicate to the victim on the record, and she can be discussed with her attorney any of the Fifth Amendment rights and the fact that that she can't incriminate herself concerning any of these matters. Is that a fair statement, Mr. Milks, that we're going to adjourn the matter? This will be a good cause adjournment. I think this is the first requested adjournment in the matter. So Mr. Embry would not be waiving any rights today. It would just be a good cause adjournment so we can clear up any issue concerning that matter.
Thank you, Your Honor. I informed my client that, we're not stipulating to it. It sounds like the court's already finding good cause here, which is understandable. And I advise my client thusly. There's really we would object, Your Honor. We are ready to go at this time. The only hardship we would have at this point is my client does have an ankle monitor on, which is affecting his ability to get job, but I can address that regarding bond, Your Honor.
All right. There are conditions of bond and there is a no contact order in place. But I do find that this, that we have to clear up this issue before we start with a preliminary examination. So we will do it. So I find good cause for the adjournment. Mr. Embry will not be waiving any rights today, and we will reset the preliminary examination. And do you want to reset it for the same time we do the motion?
Yeah.
Do you want to do it all together?
I think that would be appropriate.
Right.
Yeah.
So reset with a Fifth Amendment motion. And then Mr. Sturdivant, you should check your schedule just in case. So
I've got it in front of me, Judge. Yep.
Twenty-second at 1:30.
so that would be Thursday, July 22nd,
August.
Thursday, August 22nd at 1:30.
Your Honor, not to be that guy, but to be that guy. I'm going to be out that week.
Doesn't work for me either.
Let's get a new date.
So I'll blame Mr. Sturdivant then.
Right.
Works
I'll-
for me
I'll
if
follow
it
that.
matters.
Would the week prior be available?
15th, I'm not sure.
Judge DeLuca will be hearing the matter. We've been asked to not overlook. his
We'll wait,
document.
yeah.
So the 22nd or the 20,
He said the 22nd was in.
right, so let's try the 29th
30th.
or the 30th.
8:30.
8:30 on the 30th?
We will take that, Your Honor. That's, yes.
Does that work for your schedule, Mr. Sturdivant?
One moment, Judge. I just got assigned a new case, so I double check with that schedule. The 30th at what time?
8:30.
I'll make it look.
All right. So we've reset for the preliminary examination and associated hearing on August 30th at 8:30. This is a adjournment for a good cause. So once again, Mr. Embry, you're not waiving any rights for that adjournment. Anything else for the record in 2402-122, Ms. Wilson?
Not for the people. I understand Mr. Milks has a bond request. I will reserve my argument.
All right, Mr. Milks, you can be heard on bond.
Thank you very much, Your Honor. Your Honor, we're not asking that bond be changed except for one condition here. He is wearing an ankle monitor in this matter. We understand that in these situations, these allegations here, it's pretty typical for the court to order a GPS tether. However, unique to this case, Your Honor, the complaining witness, Ms. Kuthan, also has an ankle monitor, I believe 2 of them. So I think it can still alleviate any concerns the court may have, because at least there's monitoring going on. She's not allowed to be near my client. My client already knows he's not allowed to be near her. And obviously we're not asking the no contact order to be lifted by any means, Your Honor. The hardship to my client is that it is difficult for him to find a job. He does have, I think, 2, maybe 3 jobs right now, but it's becoming increasingly difficult for him to maintain those jobs with the ankle monitor on, as he's getting some, back talk from employers, is my understanding, just regarding that being there, and he's worried about maintaining his job or his employment, Your Honor.
All right, thank you. Any response, Ms. Wilson?
Thank you, Your Honor. Mr. Milks is correct that there is a no contact order in a different file for the complaining witness with this defendant. And it's my understanding that she does have a GPS tether in that file. I'm not entirely convinced that that alleviates the issue of the no contact order. Given the allegations here and the fact that there are allegations on a different file with other stuff going on, I just don't know that it's a good idea.
And I'm sorry, I have to correct the record, Your Honor. I misspoke. Mr. Embry has lost one of his jobs from this.
Well, there's definitely a lot going on preliminary examination in this file, and I would assume that Ms. Kuthan, part of the Fifth Amendment hearing is her. So I'm going to leave everything as is. Okay, we're going to leave everything as is. Concerning the tether until the preliminary examination. Once we see what the preliminary examination brings, then we can revisit this modification of bond. But until that August 30th date, where we're obviously going to take some testimony, the modification of bond will be denied at this time, and we'll set it to be revisited on August 30th. Anything else for the record in docket 24-02122? Ms. Wilson.
Not for the people, thank you.
Mr. Milks.
Just to clarify, Your Honor, regarding the August 30th date, that's not going to be a full prelim, is it? Should I be preparing for prelim that
Yes.
day?
Yeah,
Okay.
yeah, it's the hearing and the prelim. We just set them all at the same time.
Perfect. Thank you for clarification. Nothing further for the defense.
All right. That's all for the record in 24-02122. Mr. Embry, we'll see you on that August 30th date.
And Your Honor, he's got the notice of hearing.
Okay, sounds good.
All right, that'll work.
Okay.
That makes sense.
I mean, I need to be prepared to be involved in the conversation doing that. Okay.
All right, so are we ready to go? You let me know.
Your Honor, I believe we can call Mr. Brooks's case.
All right. On which case?
Ms. Robinson's case and
Two shooters?
and he's been.
All right, so we're on the record in docket 24-01529. That is people of the state of Michigan versus Eric Brooks. Will the parties please introduce themselves to the record? Ms. Smith.
Thank you, Your Honor. Good morning, Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Mr. Johnson.
Good morning, man. Please, Honorable Court, Kareem Johnson, on behalf of Mr. Brooks, who stands to my immediate right.
And sir, you are Eric Brooks, is that correct?
Sure.
Thank you. This is a time set for a preliminary examination in the matter Ms. Smith, how are we proceeding?
Thank you, Your Honor. Today was the date and time for the exam. The people are prepared to proceed with that exam if necessary. However, we did offer a plea agreement to the defendant, which would have been an amended count 2, an attempt of maintaining a drug house, which would become a 1-year misdemeanor, and an added count 3, use of cocaine, which is also a 1-year misdemeanor, thereby dismissing count 1 and the habitual offender 3rd offense notice. The people were unwilling to enter into a sentencing agreement on that file, and I believe the defense is requesting a Cobb's evaluation from the court.
Yeah, so Mr. Johnson, your request, so the defense at this point in time is requesting the court to essentially, without knowing anything about the case, give you a sentencing indication as to what I would do.
That's correct, Your Honor. We're asking the court essentially for no upfront jail. Mr. Brooks is accused of being in possession of 0.4 grams of cocaine. And co-defendant is, my understanding, waived the exam regarding the accusations against him.
All right, well, so all I have here is that I know about the case. So is this a bind over request or a because I lose a jurisdiction?
Your Honor, if the defendant was going to accept the plea agreement today, it would stay in your court's jurisdiction. However, I'm a bit confused. I've never been asked in this manner for a Cobb's evaluation. I don't really know if the court's willing to engage in that.
Well, I'm certainly willing to look at the and look into discussion after the pre-sentence done. After the pre-sentence is done and it goes to probation, if that's the case here. But I'm not willing to enter into a Cobb's discussion when the pretrial services has a criminal history so lengthy. Then I don't know what they're going to be requesting, and so I'm not willing to give a no upfront jail Cobb's recommendation at this time, just because I don't know anything about the case, and there are 8 or I have at least from pretrial services 8 priors, which means that I don't know what they're going to come out with. I don't know what probation is going to come up with, so I'm not going to bind myself as to any type of Cobb's to no upfront jail in this matter. But I certainly would entertain that once the sentencing is set. I would talk to both counsel if that's where we're going here, and if counsel know exactly what I'm going to sentence to, and then Mr. Brooks at that time can withdraw his plea based on the Cobb's that I represent.
Your Honor, respectfully, I believe the purpose of a Cobb's is to have the sentence agreement prior to plea so that if you didn't go along with it, they could withdraw. Right. The people would not be in support of entering a conditional plea that
I would not either. The only thing I'm indicating is that once I get, if counsel chose to talk to me, I would let counsel know in advance so that Mr. Brooks would know what he's facing, before the sentencing. I don't want to make a part of the plea agreement because I don't know. I honestly don't know what I'm going to do on a misdemeanor file without, and with this, if it was a pretrial services that came to me and there was no prior history, well, then I think I have a full understanding what probation may do with it. I have no idea what probation is going to do with this. And so I'm not willing to lock myself in on anything along those lines. Mr. Johnson, based on the court's representations, did you want some time to talk to Mr. Brooks to explain to him, and then you understand where we're going? But I'm not going to do a Cobb's today.
Yes, Sean.
All right, so let's take 10 minutes and allow Mr. Johnson to talk to Mr. Brooks, and then we'll go from there.
I think we're running on points if we want to do that.
All right, Jamar Goins.
No, I think I'm good on everything right now. Sounds good.
I'm gonna just go chat with my people right now.
Did you make sure Stover is not there?
Yes, I will.
Do you have this memorandum, Ms. Wilson and Mr. Palmer,
No,
or Mr. Milks?
No.
no.
Yeah,
Said they sent it.
I mean, you guys are basically attached at the hip. so-
yeah, so,
Wow.
Am I wrong? I feel like I did see this.
I don't know, that was sent out, so. I don't have anything for today, but I want to make sure that you have all the
Yeah, I think I
paperwork.
did see that.
I have not, but thank you, Your Honor.
All right,
So, Mr. Mills, when they say they send it to you, are you not receiving it, just so I know if I should be sending it?
Yes, so,
What?
So when pretrial services said they send you those notices of the bond violation, are you not getting them?
I do. I don't know if I got this one.
Okay, I didn't know if I should be sending
I
it to
may
you as
have.
well. I kind of take them at their word.
the only thing, I just want to make sure everybody
okay.
has the,
Yeah, you're CC'd on it.
Okay, then I did receive it, yes.
all right, so we're on the record in docket 2402-098. That is people of the state of Michigan versus Jamar Goins. Will the parties please introduce themselves to the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Mills.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Goins, who is present and staying to my right at this time.
And sir, you are Jamar Goins, is that correct? Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. At this time, the people will be requesting to dismiss count one, that's the sole felony count of the complaint, and be requesting that the remaining count, which I believe is just the misdemeanor DV, be set for a pretrial in the misdemeanor docket.
All right, and is that your understanding, Mr. Mills?
Your Honor, that's my understanding. Advised my client regarding this, and obviously there's nothing we can do with people looking to dismiss and keep some misdemeanor trial docket.
All right, so we will, I will grant the prosecutor's motion to dismiss count one. And set count two. For pretrial on the misdemeanor docket. Thank you, Megan. All right, so I'm in possession of a dismissal of count one for the felony. So Mr. Goins, I'm in possession of, on docket 2402-098, an order of dismissal or nollie cross on this file. The people are going to dismiss the felony count one count in this matter. It's dismissed without prejudice, which means that people could reissue if they choose to, but realistically, the case is dismissed today. And then count two is going to be reset on the misdemeanor docket. And do we have a pretrial date? So the pretrial on that will be August 12th at 10 a.m. And you can attend the pretrial by Zoom if you choose. All right, sir. All right. Anything else for the record in docket 2402-098, Ms. Wilson?
Not for the people, thank you.
Mr. Mills.
Your Honor, just regarding the nollie cross, it's my understanding that it's being dismissed, and I'm not certain if it was placed on the nollie, because the complaining witness at the time, I believe, said that there was no strangulation that had occurred. Is that correct?
That was what was relayed to our office. Obviously, the people are not conceding that, but based on the statement that was made, we are dismissing based on that statement, yes.
And then otherwise, Your Honor, nothing further, and thank you.
All right, and for the record, the nollie cross did indicate that the case is being dismissed because of a proof problem. All right, so we will reset for August 12th at 10 a.m. based on the remaining misdemeanor count. That's all for the record in that file. Thank you, everybody, for your appearance.
Very good. Thank you, Your Honor.
And then I think we're ready with Matula.
And Ms. Robinson is here on
Jones and Tuyashimi
Tuishimi. I think
and Schneider.
we have an interpreter on Tuishimi.
Yes.
Correct.
Is he here?
Yes.
Okay.
Yes. Is Tuishimi here?
Yes.
All right. Did you need to talk with?
I've already talked to him.
Okay. Let's go. Is that a prelim or is that?
No, that one is being, that one's being treated as a PCC today. We want to go on that one. That's fine.
Yeah, just
Just
because
so
we
we
have
can
the
get-
interpreter
yes,
here.
Get you out of here.
That's a good idea. All right, so the interpreter can come forward on that case.
I'm sorry.
I know, and the interpreter's been waiting. All right, ma'am, so I'm gonna have you state your first name and your last name for the record and spell each one.
N-I-S-I-O-S-E.
You're gonna have to go slower because I did, and we should turn off that fan just in case. All right. All right, ma'am, so spell your first name for the record.
N-I-L-I-O-S-E.
Okay. And then your last name is pronounced? Say that again, ma'am. Louis Bundu.
Yeah.
And then spell that for the record.
W-I-M-U-N.
All right, ma'am, I'm gonna have you raise your right hand. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications, so help you God under the penalty of perjury? All right. So you just let me know if we get going too fast, all right?
Okay.
All right. So we're on the record in docket 24-01331. That is people, the state of Michigan versus Chance Tuishimi. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Mr. Tuyashime.
And this is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
I would defer.
Ms. Robinson.
Yes, Your Honor, we're going to be asking that this matter be set for a preliminary examination. Today, we are treating this date as a PCC date because of some previous issues with getting an interpreter.
And you'll be able, can you translate that to Mr. Tuishimi? All right, so this is left on for preliminary examination. I have, so let's get a date for that. Let's get a date for the prelim. Do we have a time frame that we're?
If we could do it after the week of the 12th, because I'm out that week.
All right. So after the week of the 12th.
August 22nd at 8:30.
August 22nd. At 8:30. I think that just in case, this is an adjournment for good cause, because it's a good cause adjournment so Mr. Tuishimi, he won't be waiving any rights today.
So they're gonna be waiting for August 22nd.
Yeah, the actual prelim will be held on August 22nd at 8:30. And we'll have it may be you, it may not be you, but we'll have an interpreter present on that date. And what language is that, ma'am?
Rwanda. Kinyarwanda.
You're gonna have to spell that for me.
K-I-N-A-R-W-N-D-A.
Say it again, KIAA.
K-I-N-A-R-W-N-D-A. NYARWNDA.
All right, so on the August 22nd date, we'll have an interpreter present, and that'll be the date assigned for preliminary examination. So, this is a good cause determinant. So, the good cause being that there were some language issues, and so we want to make sure so we want to make sure that the hearing will be outside of the 21-day period. But I find that this is a good cause to adjourn. Yeah. So he's not waiving any rights because he has a right to a prelim within 21 days. And we've reset it outside of that time frame, but we've done it for good cause to get all the interpreter and make sure everybody has the interpreter and the defendant has all his rights so he understands what we're doing. Okay. All right, so it's reset for August 22nd at 8:30 for preliminary examination. Anything else for the record in docket 24-01331, Ms. Wilson?
Not for the people, thank you.
Ms. Robinson?
No, Your Honor.
All right, I will see the defendant again on August 22nd at 8:30. Thank you for your assistance today, ma'am.
Do you want to do Schneider?
Yeah. This one was- King or Wanda. So but there is an interpreter. There's a stamp too.
Yep. Do you need something signed, Pam? Yeah, yeah, no, if you just want to hand it to the lady in white there, she can get it for you. You are the lady in white. I think you just hand it to Wendy and she does something with it.
That's the answer. I wasn't sure if it was supposed to go like to Susan or something.
24-01529. That's People of the State of Michigan versus Eric Brooks. And Mr. Johnson, you've been given the offer, and have you had some time to speak with Mr. Brooks concerning this matter?
Yes, Your Honor.
All right. So how are we proceeding today?
It's gonna be a plea, Your Honor.
All right,
May I approach?
you may. All right, thank you, Mr. Johnson. So so state the plea for the record once again, Ms. Smith, so there's no
Absolutely, Your Honor.
misunderstanding.
Count 2 is going to be amended to an attempt maintaining a drug house. That takes that down to a 1-year offense. The people are also adding a count 3, use of a controlled substance, cocaine. And that's 333.7404 2A. Also a 1-year misdemeanor offense. In exchange for the defendant's guilty plea to amended count 2 and added count 3, the people dismiss count 1 and the habitual offender notice, and that keeps this file here in the district court. There is no sentencing agreement at this time.
Right, I have, so the amended count 2. Is the attempt maintaining of a, how did you refer to that?
Attempt maintaining a drug house, Your Honor.
And that is a 1 year
Yes, Your Honor.
and or,
The original fine is 25,000, so if I can do math, 12,500.
and then there's, is that an added count 3 or is that the count 3?
It's an added count 3 or an amended count 1. I never am certain how the district court likes it done.
Let's do added count 3 because we're
Okay.
going to dismiss count 1 as part.
That's
yeah.
the way I have it too, Your
All
Honor.
right.
Yep, added count 3, use of cocaine.
All right, and that's pursuant to 333.74042A.
Correct.
1 year and another 12.5.
2,000 on that one, Your Honor.
All right. Right, and with a plea to count 2 and 3, count 1, and the habitual notices to be dismissed. Mr. Johnson, is that your understanding of the plea agreement?
Yes, Your Honor.
Thank you. All right, may I inquire of your client of his advice rights? You've had the opportunity to give the court the advice rights, so I'll just go over the main 3, all right, sir?
Yes, Your Honor.
All right, so Mr. Brooks, you understand that you are pleading guilty. The ultimate punishment could be 1 year, as to count 2, could be 1 year or $12,500 in count 2, and 1 year and or $2,000 in count 3. Do you understand that, sir?
So how many counts do I have?
You have right now, you have 2 counts. All right. What they've done is they've amended count 1. We've amended count 2 to a misdemeanor count, so it's a 1 year in front of the court. And then count 3 was added as a use of a controlled substance as a misdemeanor count, and they're dismissing the 4-year felony in the matter. So they've added 2 misdemeanors and dismissed 1 felony. So you understand that?
Right.
All right. And you've signed the advice of rights concerning this plea, is that correct, sir?
That's correct.
All right. So, and there's 12 rights on this that you've signed. I'm going to go through the 3 main rights. You have a right to be tried by a jury. You understand that, sir?
Yes.
You have the right to have the prosecutor prove beyond reasonable doubt that you are guilty. You understand that, sir? And you have the right to have you have the right to choose to testify at trial if you choose to. You understand that, sir? All right. You're represented today by Attorney Ms. Kareem Johnson, and he would be present to cross-examine any witnesses, contest any charges brought against you by the people of the state of Michigan. You understand that if your plea is accepted, you'll give up the claim that the plea was a result of any promises other than what we've stated on the record. Okay, so they put on the record that it's a plea to count 2 and 3, dismiss count 1. All right. Do you understand that, sir? And you understand that you won't be appealing anything from trial since you don't have a trial right. You'll be pleading guilty instead. Is it your wish today to plead guilty to the attempting of maintaining of a drug house and the use of controlled substance?
Yes.
All right. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, I'm going to bring your attention back to May 23rd of 2024 at the location of 1610 Lockbridge, City of Lansing, Ingham County. Were you present on May 23rd, 2024 at 1610 Lockbridge in the City of Lansing? All right, and at that time, pursuant to count 2, on that date and time, did you attempt to maintain a drug house on that date?
Yeah, may I?
You may ask any questions.
On that date, did you own or rent the 1610 Lockbridge, Lansing, Michigan home?
Yes, I own.
On that date, did you store some cocaine in that residence?
I didn't store no cocaine, but they found a little piece of cocaine in my residence.
In your room?
That's in my room.
And it was yours?
Yes. It was.
And you knew it was there? You put it there at some point?
Yeah, at some point I put it there.
Yeah, the defense is satisfied.
Ms. Smith, anything towards the factual basis in count 2?
Yes. Mr. Brooks, you also knew that Mr. Henton was staying there, is that correct?
Yes, I let him stay there for a few days.
Okay,
Because he was
and-
homeless.
Okay, and did you tell the police that you suspected that Mr. Henton was dealing drugs out of your
I
house?
did not.
You did not tell that to
I
the
did
police?
not tell them that. I didn't know any of his business. I did not tell the police that he was selling drugs out of my house because I would.
Did you use drugs with Mr. Henton in your house?
He smoked weed.
Was there other paraphernalia found in your house, such as trays and razors?
That was his, yes.
Okay, so you knew Mr. Henton was using drugs in your house?
Right, we were doing.
Okay.
Yeah.
People are satisfied.
All right,
Thank
I
you.
think that suffices for the attempt for count 2. And then on that same date and time, which is May 23rd, 2024, on Lockbridge in the City of Lansing, did you use cocaine, sir?
I did.
Okay, and did you knew it was cocaine when you used it?
I did.
All right. Anything towards the factual basis, Ms. Smith?
No, Your Honor, thank you.
All right, I find the factual basis to the amended count 2 and the added count 3 to be knowing, voluntarily, and accurately made. And we will refer to probation. So, Mr. Brooks, go ahead. Probation's on the 5th floor. You'll go down there, they'll make a report for me, and then we'll see what options are available to me at sentencing, okay? We'll set sentencing date for
September 26th at 9.
September 26th at 9 a.m. So go down and get that. They'll either give you a date or they'll see you today, all right? But what they're going to do is do a report for me. And then on September 26th, we'll see what options we have available to us, all right? Anything else for the record in 2401529, Ms. Smith?
No, Your Honor, thank you.
Mr. Johnson?
No, Your Honor, but on that day, I should be finishing a week-long trial in Osceola County.
Did you want to set it later? Or?
No, I want to keep that date.
Okay.
Because that court will allow me to Zoom
All right.
from that court to another court.
All right.
So if the court will allow me to.
I don't have any, as long as Mr. Brooks is here for the sentencing, I don't have any preference.
I have no objection to appearing by Zoom,
Right.
or if there's any reason that it needs to be moved, I will work with Mr. Johnson on that, no
All right.
problem.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
All right. You're all set, Mr. Brooks. Thank you.
I don't know if I can reach you. Oh, sorry, I should have given it to you. That would have been way easier than me trying to do it myself.
The lady in white.
The lady in white.
Thanks, Mom.
Megan, have you ever been referred to as the lady in white?
No, I have not.
Sounds good. It sounds a lot more
It does.
ominous than
It
it
sounds
is.
so
I was gonna say, I don't know what it means, but I like it.
It sounds very sophisticated. All right.
I think all we have left is Jones.
I think that I really don't have any
Ms. Smith, you've definitely earned your paycheck today. Huh?
Thank you, thank you. All I request in exchange is that when we build a new courthouse, could the air conditioning work? Correct.
Yeah, that seems like a reasonable request.
Oh, I think so,
I
but
thought that's what Natalie
It
told us
seems-
it would.
Before we go on the record.
Natalie and I are doing it together. Oh,
You should talk to Ms. Robinson. She's your lawyer. If you have any questions.
Yeah, because they're having a hearing, so they always make the hearings go last. It's just the way it is. It's just court, dude. I can't do anything about it.
All right.
Two officers, I'm not sure what happened today.
I believe the people have arrested and Ms. Robinson is calling an additional officer who is present in the jury room.
All right.
Although my understanding is he's asleep right now, so somebody might need to wake him
Well,
up.
he won't be for much longer.
All right, so we're on the record in docket 24013668. That is people of the state of Michigan versus Tyrese Jones. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Robinson,
Erin Robinson, Assistant Public Defender for Mr. Jones.
and sir, you are Tyrese Jones, is that correct? All right, thank you. This is time set for prelim, and it's my understanding with that this is a continuation of a previously held prelim. We had I have Officer Donovan Moore testified
And Officer Jamil Jones.
and Officer Jamil Jones. All right. And the people have rested and the defense requested to call a witness in the case, and that's Officer Stover, I believe.
Correct.
Okay. And so, Ms. Robinson, are you ready to proceed on your direct examination of Officer
I'm
Stover?
trying to get my computer to turn on. Once that happens, I'll be ready to go, but right now it's having issues. So that's great.
Courtroom.
It works this morning.
But when you need it, it's not gonna work. The court.
I need the body worn cameras on my computer.
I mean, I can pull up e.com if you need it. No.
I have it downloaded so that way.
Oh, okay.
Oh, it is?
Yeah.
Well,
Oh,
that's
then
why,
that's
bud.
useless.
It's
Yeah.
just pooping the bed right now.
Correct.
Just trying to come to the rescue and.
That's what you get.
Yep.
Right, that's what you,
Mock.
no good deed.
No, absolutely. Do you want my computer?
thank you so much. Have a great weekend.
Maybe if I just hold it for a really long time.
But she's got it downloaded on hers, is what she's saying.
Okay, I think it might have turned off. Let's see if it will turn on.
This is not a commercial for Dell, is it?
We were supposed to get new computers this year, but IT just hasn't ordered them for us yet. Yeah, so I guess we don't need them. So I just deal with this all the time. It's great, it's fine. There's no issues.
All
I
right.
think it's turning on now. Look.
Oh, look, you did it.
See? It's working now.
All right, so let's call Officer Stover on behalf of the defense to the stand.
You're looking for?
You need Mr. Milks?
He's not doing anything.
Yeah, he's not doing anything, so he's
I know.
free.
Wow.
Use your trust.
I know.
I don't know who's harder on Mr. Milks, Mr. Palmer
Yeah.
or yourself.
Oh,
The unkindest cut.
Yeah. It's Officer Stover, right?
Officer Tyler Stover.
All right,
All right, we'll go grab him.
all right.
I think my computer is starting. now.
More justice done.
That's the one I have with him too.
Not from the jury room. Do you know where he went?
He was in the
He wa-
jury.
yeah, no, he
room.
was. I
Oh, it's
talked
not
to him
the
this
judge. He might have, maybe gone.
So let's go off the record till we find this.
Yeah, that's, yeah. Sorry.
Yeah.
Do I have, I don't think I have his cell.
How that gets to go in.
Some of that.
She was in the bathroom. I found him.
All right. Go back on the record when he joins
Yeah.
us. Officer Stover, we're back on the record in docket 24-01368, and I'll have you come up here and then face me. Please state your full name, spell your first name and last name for the record.
Tyler Stover, Tylerstever.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I swear.
All right. Go and have a seat. As you know, the microphone is for recording purposes, so please project as best you can. And Ms. Robinson, you may proceed.
Officer, can you please state your name for the record?
Officer Tyler Stover,
And officer, where are you employed?
with the Lansing Police Department,
Okay, and how long have you been employed there?
just under 3 years.
And do you remember an incident involving a Tyrese Jones?
Yes, I do.
Okay, and did that occur on May 6th of 2024?
That's correct.
Okay, how were you involved with Mr. Jones?
I was dispatched to a shots fired in the area of Duvernay. And I got out there and there was quite a large group of people out there.
Okay, I want to take you back to what you were dispatched for. You stated you were dispatched for a shots fired complaint. Was there any more information given, or was that the only thing that was given?
I believe it was, there's a black Corvette driving recklessly and allegedly someone shooting out of it.
Okay, and that was in the area of Duvernay, and what was the other street? I'm sorry.
I don't recall the cross street, but Dunkel, I think, is another nearby cross street.
Okay, so you went to that area, and then what happened?
And I observed a vehicle on the roadway, and there was a subject standing in the roadway with a cell phone. And as soon as he saw my patrol car, he took off running towards an apartment on Duvernay.
That subject, what was he wearing? What was his description?
He was a black male wearing a black shirt and black pants, I believe.
Okay. And you said that he ran as soon as he saw you?
That's correct.
Where did he run to?
He ran towards the apartments on Duvernay.
Okay.
It was apartment 4839 that I saw him run into.
And did you head then towards those apartments?
I did.
Okay, and what did you do then?
I just made contact with a couple people out there and waited for some other officers to get in the area.
Okay, and when you arrived on scene, what did you notice?
About what specifically?
Were there a lot of people around? What was happening, I guess, when you got?
It looked like they were partying outside, yeah.
Okay, so they were partying. Can you tell me about how many people you saw outside?
If I had guessed, around 20 or 30 people probably.
So there was a crowd.
Correct.
Okay. Now, when you walked up to the apartment complex, did you notice anything after that?
Not that I recall. Can you be a little bit more specific?
Well, I'm trying to get you, so how did you become involved with Mr. Jones?
I believe some other officers were trying to detain Mr. Jones, and I walked up and assisted them and put handcuffs on Mr. Jones.
Okay. Did you see Mr. Jones come out of the apartment complex?
I don't know where Mr. Jones came from.
Okay, you don't know where he came from. When you saw Mr. Jones, what was he wearing?
I don't recall what he was wearing.
Okay, would looking at your body worn camera footage refresh your recollection?
Correct.
May I approach, Judge?
You may.
Is this your body worn camera footage? You
I
looking
believe
at-
so.
And is this in the body worn camera footage, Mr. Jones?
I can't tell.
I can play with it a bit.
somebody shooting around the corner. Walking outside of the apartment that I just walked.
Do you recognize him as Mr. Jones?
I believe so.
Okay, and what is he wearing?
He's wearing a red bowler jacket.
Black pants?
Correct.
Was that the man that you saw run from you?
I don't know.
Well, the man that you stated earlier that you saw run from you, he was wearing a black t-shirt and black pants, correct?
Correct.
Okay, now, Mr. Jones is not wearing a black t-shirt, correct?
Correct.
He's wearing a jacket.
Right.
So is that not the man who ran from you?
I don't believe so.
You stated that he walked out of the apartment and then, or well, you didn't see where he walked out of, but he came out of somewhere. And then he was detained by officers, correct?
Correct.
Okay. Was he arrested for anything
I
at that
don't-
time?
I don't know. I don't recall. I didn't have any further contact with him other than assisting with putting handcuffs on.
Okay, so did you pat him down at all?
I don't recall if I did or not.
Now, I want to go back to the car in question, because you stated that the dispatch was for I guess, a black Corvette firing shots, correct?
Correct.
Okay. Did you ever look inside the vehicle?
Not that day, no.
Not that day. Okay, but at a later date, did you look inside the vehicle?
At a previous date, the night prior, I looked inside a similar description of the vehicle.
Okay. Did you find an identification card in there?
No.
Okay. Did you find out who the vehicle belonged to?
The previous night, I was looking at the vehicle because a similar vehicle had ran from another officer. I found that vehicle parked in the same area.
Okay. Did you find out who the owner of the vehicle was?
Yeah, a male approached me, I believe it's Taylor Smith, I think is the subject who approached me, and he stated that it was his vehicle.
Okay, so it wasn't Mr. Jones who owned the vehicle, correct?
That's correct.
I don't have anything further.
All right, cross-examination, Ms. Wilson.
Briefly, Your Honor. So Officer Stover, you're responding to a shots fired complaint, correct?
Correct.
So there's a concern about the safety of the public, correct?
Correct.
And the safety of the officers there, correct?
Correct.
And there's a lot of people, right?
Yes.
And so it's kind of a chaotic scene, right?
Yeah.
And you don't really know who you're looking for at that point, other than the person that you kind of saw run, correct?
Correct.
And you saw him run into this general apartment area, right?
Yes.
And then you and other officers are trying to figure out who that person is, correct?
Correct.
And you're in that general apartment area that you saw him run to, correct?
Correct.
Okay, and at that point, the main concern between yourself and your other officers is public safety, safety of officers, right?
Correct.
Okay, nothing further.
Any further redirect after cross-examination, Ms. Robinson?
No, Your Honor.
May this witness be excused from the defense,
Yes.
from the people? All right, Officer Stover, thank you for your appearance tonight. Any further proofs today, Ms. Robinson?
No, Your Honor.
Does the defense rest now?
It does.
All right, a motion for bind over, Ms. Wilson.
Thank you, Your Honor. The defendant in this matter is charged with resisting and obstructing a police officer. We have testimony previously from Officer Donovan Moore, as well as Officer Jamil Jones. There doesn't seem to be a debate as to the date or location of the incident. So I believe that the date and venue have been satisfied to a probable cause standard. Officer Moore and Officer Jones both identified the individual present here today as Tyrese Jones, the individual that they had detained on that night. From all three officers, there's a concern here that there's a gun fired, there's somebody running towards a general apartment complex. There's a lot of people. It's chaotic. There's a gun involved. Everybody's really concerned about public safety and the safety of the officers. It's chaotic. People aren't cooperating. They see an individual coming from that apartment complex, as Officer Donovan Moore and Officer Jones testified to. They try to give him a command. He's not listening to it, so they detain him as he is present in the area coming from the apartment complex that is in question, and he is not complying with lawful commands here to go on the sidewalk or to go to a certain location. Lawful commands which they are able to give as community caretakers and officers investigating a crime. It doesn't matter that if Mr. Jones is the individual that committed that crime at that point, they have a reasonable suspicion that that individual is in the area. There's a chaotic scene, there's a potential gun involved. They have the authority to tell people to go certain places in order to control the scene. He doesn't do that. They detain him. At that point, they're trying to identify him to possibly rule him out from the issue. At that point, he becomes belligerent, starts kicking. At one point, I believe one of the officers testified that he kicked at the officers. He pretends to have a seizure. At some point, he tries to run away from the officers. All things that clearly fall within resisting and obstructing their lawful commands to stop, to calm down, to be identified so that they can release him at that point if he is not the person that they're looking for. Based on the questioning that was done here today, I think we're skirting around claiming that resisting and obstructing has to be an arrest. That's not true. It has to be a lawful command or a lawful detention. Clearly, we have that here today. There's a reasonable suspicion that something's going on. There's a community caretaking or effort here to ensure public safety. There's a potential Terry stop going on here because he's coming from the general location that this individual ran to. Yes, he's wearing a different shirt, but I think both Officer Moore and Officer Jones testified that there was enough time for him to potentially change his shirt. So there is a lot of question about who this person is, where he's coming from, whether or not he has this gun they're looking for. He's obstructing and resisting these officers in probably the clearest way by physically resisting them. So I think that the elements here have been met, and I'd be requesting bind over.
Thank you. Ms. Robinson, response.
Yes, Your Honor. I want to first briefly address this people stated that he didn't comply with commands originally. That's simply not the case. We heard no testimony from any of the officers that he did not comply with commands. In fact, he was only placed under arrest for resisting arrest once the officer, once he refused to give his identification to the female officer, and then she pushed his legs into the car, in which case he pushed back. So until then, there was no physical resistance from him. There was no him saying he's going to refuse or do anything like that. He did comply completely with commands, and there has been no testimony otherwise. I want to point the court to People versus Moreno and go into some legal arguments here. There's three elements that the state has to prove for resisting and obstructing charge. First is that there wasn't a resisting and obstructing of a command or from an officer. They have to know that the officer was performing their duties, and that the third prong is that the officers acted lawfully in their arrest or detention of the person, and in this case, Mr. Jones. We're focusing on prong number 3 here today. And I think that's the big thing, is that officers didn't have a valid reason to detain and to arrest Mr. Jones at this point in time. Also going to focus on some other things as well. So there, with the seizure, the law states that that's a physical hindrance of someone, and instruction to stay is required for any sort of seizure to occur. As the court is probably well aware, a brief detention requires reasonable articulable suspicion, but an arrest requires probable cause. If we look at the facts in this case, we know that there was a dispatch advised for shots fired from a vehicle. Officer Stover testified today that it was a black male wearing a black shirt, black pants, and that he ran into the apartment complex. When he arrived there were multiple people outside. Mr. Jones comes out, he's in a red jacket. And once he comes out, he's handcuffed, he's patted. We heard from Officer Donovan Moore that he's patted down and he's taken to the police vehicle immediately. Once he's patted down, the officer did testify that nothing was found on his person. Therefore, there was no suspicion of a crime at that point. They requested Mr. Jones's name multiple times, which he didn't give his name at any point in time. But in this case and in this state, there is no requirement that you have to give officers your name if they don't have a reason to detain you or to stop you. The only time that he resists arrest is when he's officially placed under arrest and his legs are pushed into the vehicle. That's when he pushes back. I want to point the court's attention to a case called People v. Murowski. I'm not sure if the court's familiar with that, but I do have a copy, and I do have a copy of the case for opposing counsel as well, if I can approach.
Thank you. Thank you, Ms. Robinson.
In this case, People v. Murowski is very similar. It's a 2023 case, so unfortunately it doesn't have a site yet, but it's a case where the police were called into, a store where the store owner stated that they wanted the person trespassed. They went in, they said that the store owners stated that the defendant was making a disturbance in the store. They asked that person for their ID. The officer said he's going to jail if he doesn't give him his ID. That the defendant in this case then was arrested and then bit the officers. The court in this case held that the defendant properly resisted arrest. And it also stated in this case as well that failing to provide an ID is not a crime, and it's not required without proof that a defendant engaged or will engage in a crime. In this case, it's very similar to what Mr. Jones is going through. We have this case where Officer Stover has received, is going on scene for a dispatch for shots fired. He says he sees a black male in a t-shirt, or a black male, black t-shirt, black pants, go run from him. He sees Mr. Jones comes out. He says that Mr. Jones isn't the same person he doesn't think that he's the same person as the person who ran from him. Is it possible that Mr. Jones possibly could have changed clothes? Yes, but we don't have any proof of that. That's just allegations that are just being, I guess, conjectured here for the court to look at. He comes out, he's immediately detained and handcuffed. There's probably a group of 20 people that are around the scene. Not everybody on the scene is handcuffed. It just seems to be that Mr. Jones is handcuffed. He doesn't resist arrest physically once he's handcuffed. He's not pulling away from officers. The officers handcuff him. He immediately goes to the police vehicle afterwards. They do a pat down of him and they find nothing on his person. They don't find any evidence of a gun. They don't find any evidence that he's armed in any way or any other evidence that a possible crime has occurred. So if we're looking at it from a possible Terry point or Terry stop point, which requires reasonable articulable suspicion of a crime, brief detention is allowed under a Terry stop. He was patted down. Nothing was found when he was patted down. And that should have been the end of it. There's nothing more for reason for him to be detained. But I don't even think they really had enough in this case to briefly detain him for a Terry stop either. There's nothing here that shows that he committed a crime in any sort of way. He doesn't match the description. Officer Stover doesn't really think that he stated today, he doesn't really think that it's the same guy who he saw run. There wasn't a real reason to detain him. Now, I understand that situations get tricky and officers have to worry about their safety, but just because officers have to worry about their safety doesn't mean they have the right to arrest everyone. And what happened to Mr. Jones, I believe, is more than a brief detention at this point. I believe it's an arrest. An arrest requires physical hindrance and the command to stay, which is what I believe it's People v. Johnson decided. And that is basically what happened here to Mr. Jones. He was arrested. And all of the officers that testified in this case have testified that he wasn't arrested because he committed a crime. He was simply arrested because of the situation that was ongoing. Now, if the court even agrees that they had a right to stop Mr. Jones to do a brief Terry stop, then the court can look that was immediately done. That brief detention was immediately completed. He was patted down. There was no weapons found. This is a shots fired complaint. They don't find anything on his person. They don't find any, he doesn't match the description. They don't find anything on his person. At that point, there's no continuance to continue the encounter or to continue the detention further. So it's my position that Mr. Jones had the right to resist the arrest in this case because it wasn't a lawful arrest. Lawful arrest requires probable cause. There's been no evidence in this case put forward by the prosecutor that states that there was probable cause for any sort of crime that Mr. Jones committed in this case. Thank you.
Thank you. Response, Ms. Wilson.
Yes, Your Honor. So first of all, I don't think that is the correct. Granted, it's been a bit since we had the last hearing, but my recollection of the testimony was they're at the apartment complex. They see Mr. Jones come out of the apartment complex. They tell him, go over here. He doesn't do that. He keeps walking towards them. At that point, they detain him. At that point, that is a lawful command that they have given him, and they detain him. And I think there is a reasonable suspicion here. The case that Ms. Robinson has cited also cites People v. Quinn, where under certain circumstances, a police officer may approach and temporarily detain a person for the purposes of investigating a possible criminal behavior, even though there is no probable cause to support an arrest. A brief detention does not violate the Fourth Amendment if the officer has reasonably articulable suspicion that criminal activity is afoot. Whether an officer has a reasonable suspicion to make an investigatory stop is determined case by case on the basis of the analysis of the totality of the circumstances. A determination regarding whether a reasonable suspicion exists must be based on a common sense judgment and inferences about human behavior. So, and I think a lot of the arguments we're making here today are based on hindsight. We have testimony here today that looking at the body cam, yeah, that doesn't really look like the person that I saw. We have no testimony here today that at the time Mr. Jones was detained, they didn't think that he was the person that they were looking for. There's testimony that he went into that somebody went into an apartment. Mr. Jones came from the area of that apartment. He generally matched the description. There was enough time for him to change his clothes. There's shots fired. He's not complying with commands to go to a certain place. That all right there is a reasonable suspicion. They can detain him at that point. They detained him. Yes, Terry is for weapons, but if we're looking at Quinn, it's also for investigatory purposes. At that point, they have a complaint of shots fired. They have a lot of people in the area. They don't know what's going on. There's a gun involved. There's a lot of shootings going on in Lansing, as Officer Moore testified about. There's a serious concern about public safety here. All they wanted to do was clear Mr. Jones of being the person they were looking for. They tried to do that. They couldn't. They have the ability to extend that detention until their investigation is completed. So the investigation there is completed. He wasn't arrested at that point. He was detained. He was detained and he was arrested, yes, after he started resisting that detention. The detention is lawful. The resisting of the detention is a resisting and obstructing. There is case law that even putting somebody in protective custody loses the right to resist that detention. So I mean, if we want to brief this issue, I'm fine with it, but I think at least to a probable cause standard here, there's a reasonable suspicion, there's a lawful detention, he's resisting that lawful detention. We have a resisting and obstructing. Request bind over.
Thank you. Part of the, so I'm going to take the motion under advisement, and I think Ms. Wilson, Ms. Robinson, you probably saw this coming, mostly because we have a bifurcated prelim. And so I want to see what was said at the first I don't want to go on my notes. I guess that's my fear, is that I'm making a decision based on testimony that is, I think May 6th was when the testimony was given. So that, I mean, that's a good 2 months away. And so let's do that. And what I want to do is also is council in the interim, we're going to reset it. But council in the interim can provide any documentation or any argument based on the Murkowski case, and you probably want a chance to respond to that. And any other case that Ms. Robinson is able to address. And I don't want to create work for you, but so don't feel like you have to give it to me in a brief format. You can give it just to guide. I'm looking for guidance. But if you want to do a brief and you want to make a motion, that's fine also. Okay, I have no preference. What I'd like to do is go back and listen to the testimony and have council the opportunity to review the testimony so that we're in a better position for the arguments, although the arguments are in an indication that this case is deserving of it. Okay, so May 6th preliminary examination, we had 2 witnesses testify. I'd like to go back and review that testimony to make sure that my notes are in accordance, and I certainly don't want to make a decision just based on the notes of that testimony.
I would prefer if, sorry to interrupt. I was just going to ask if we could submit those, the memos or briefs after we receive the transcripts.
I was just gonna ask if we could get the transcripts.
I think that's fair. I think it's fair that you review the testimony and then you have the opportunity to refashion whatever argument based on what you reviewed, because all our notes are problem. Especially, I'm only speaking of myself. My notes are problematic. I have 3.5 pages of notes from the testimony, and I can read about 1.5 pages of it. So I mean, so let's get it in. Let's get it in the transcript form. So and then we'll set it for the. We'll set how long do you think it will take to get the transcripts to you?
That's a
Probably a
question.
bit.
Yeah.
Neither Tammy or I was going to be able to get them done anything less than 45 days. The hearing was on June 27th. I can't see it at the moment. Tammy and I both have other family commitments coming up that prevent us from being able to immediately do this.
So let's set the prelim date out, and then we'll set it out 60 days.
Okay.
And then any response will be that. So we'll have a 60-day time period to, and then we'll go from there. But and then any response or any can be a week or 2 before that prelim is set for. That should give us at least a control date so that we don't adjourn without a new date. And then we'll see. I don't believe either the testimony from the first prelim is long in any way. It's less than an hour of testimony, I think. But,
Just a matter of the manpower to get it done.
it's just a matter of getting the manpower to get it done. So we'll set for motion. So we're not setting for additional testimony. It's set for motion for bind over.
Oh, yeah.
And we'll set it up 60 days out. It's a motion date, so we can, as long as it sets, it'd be easier to do on a PCC or prelim date because I know where to find everybody on that date. But it's up to you really, because we're not going to take any testimony.
I'm here
I'm on
Monday,
the first
Thursday,
week of
Friday.
October though. So not the first week of October.
Okay.
So let's go to the second week of October.
October 10th at 9.
Okay. Now we don't even know what's scheduled then. So October 10th, but we know this is scheduled then at 9. And that would give everybody a review date. So motion is set for, that will give everybody a chance to review the testimony and then to supplement any arguments with case law. I think that's the fairest way to go in this. All right, so we've reset the motion for bind over and I'll keep the
Yeah.
Morosky case for October 10th at 9 a.m. And then previous to that date, if you want the court to consider any other case law or argument, you can provide that in writing. All
Thank you,
right,
Your
all
Thank
right,
you.
all right.
If you guys want to copy the transcript, I will need you to sign the transcript. first.
Yep.
Yeah,
All
no
right.
problem.
Okay.
Yeah.
Otherwise, I'll just go to judge.
Right, so that's all for the record, 24-01368. Thank you, everybody, for your appearance today.
If we have the mouse, right here, perfect.
All the notes.
Yep, I'm gonna, Tammy, I'll need it to type it. She signed it. So I don't know if that's gonna matter.
So we've got the murder trial, that's the Labrie is this afternoon.
Yeah,
More you've started, I thought.
no, we have not. That's a
I don't
new-
know if we started.
That's a new case. We finished his other case.
Risper
Risper.
is a new case.
It's not really, no.
It's a new
We
case
haven't
because we've not
started
started
yet,
it.
correct.
And I don't mind starting them, so.
I would like
But,
to start it.
yeah, this is the only thing that in this is that I don't mind starting them, but then we've got to recall what happened in the past.
yeah.
That in that case, it becomes a problem. I have a violation of probation for Mr. Sanders and an arraignment on Mr. Sanders.
We also have walls this afternoon,
Yeah, and then we have a prelim on Walls.
which is gonna be its own beast, because that's another Fifth Amendment thing. That's the one we had the immunity petition on.
All right. We'll wait to hear from you on that. All right. Busy morning.
It went better than I thought.
No, it went very well, but
Yeah.
that's a lot of
It
cases.
was a lot, yeah.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 13 prelims. I mean, that's no small day. You go up north and they've got their big prelim day is like three
Yeah.
prelims set for the day.
Right.
It's like,
I
wow.
was like, oh, that must be nice.
There's a little difference in volume. And then you go to Wayne County and they've got, 20
50,
sets.
yeah.
All right. So I will definitely see, Ms. Robinson, we don't have you on anything this afternoon, do we?
Nope.
We have Sarge Schroeder. All right.
I'm here, but not here.
Starts, White, Cornish,
Cornish.
somebody else.
Well, we know where to find you.
Yeah.
All right, I'm gonna leave everything up.
Can you mute the courtroom though, Judge?
Yes.
For the person that's identified on Zoom as RISPR, identify yourself. The person identified on Zoom as RISPR, please identify yourself.
will be Mr. Creno's case.
If you're doing that, I need to go call Mr. Stevens real quick.
All right, let's go on Mr. Labrie.
Yeah.
All right. So we're on the record in docket 24-01532. That is People of the State of Michigan versus Brandon Labrie. Will the parties please introduce themselves for the record? Mr. Creno.
Your Honor, good afternoon. Assistant Prosecutor Bill Creno on behalf of the people of the state of Michigan.
Mr. Cornish.
Good afternoon, Your Honor. May it please the Court, Deputy Chief Public Defender on behalf of Mr. Labrie, both appearing via Zoom. Mr. Labrie from the County Jail.
Thank you. And sir, you are Brandon Labrie, is that correct? And sir, you are Brandon Labrie, is that correct?
Yes.
Thank you. This is the time set for preliminary examination today. Mr. Creno, how are we proceeding?
Your Honor, thank you and good afternoon. My understanding is actually we are set for a probable cause conference here today.
That's true. That's true.
No problem, Your Honor. The defendant was previously found competent to stand trial. We had a hearing before the court just recently, and this probable cause conference was set here today for purposes of potentially setting a new preliminary examination date. Your Honor, after speaking to Mr. Cornish, my understanding is that the defendant will be unconditionally waiving his right to preliminary examination, however, here today. Your Honor, the record should reflect that there are no plea offers or agreements at this time. Plea negotiations, if any, will continue in the circuit court. And for the record, Your Honor, the people would also so waive our right to preliminary examination here this afternoon.
All right. And is that a fair statement, Mr. Cornish?
Yes, Your Honor.
All right. So it's my understanding this is an unconditional waiver from both sides and negotiations are to continue in circuit court. Is that correct, Mr. Creno?
That's correct, Your Honor. Thank you.
Mr. Cornish, may I inquire of your client of his waiver of the preliminary examination?
Please, Your Honor. Thank you.
Thank you. Mr. Labrie, you understand you have a right to a preliminary examination today or a scheduled preliminary examination. You have a right to preliminary examination. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Stephen Cornish, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish today to waive your right to a preliminary examination and have this case continue to circuit court where negotiations are to continue. Is it your wish today to waive your right to a preliminary examination, sir?
Yes.
All right. And Mr. Creno, as indicated previously, you're also waiving the prosecutor's or the people's right to a preliminary examination.
Your Honor, yes, that's correct. Thank you.
All right. I am in possession. So I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will ask, I have the documentation for bind over. I'm going to indicate the examination has been waived on today's date, which is 8/2/2024. I will ask Mr. Creno, can I sign this via Zoom? Do I have your authorization to sign this via Zoom? I'll just put via Zoom by attorney. Would that suffice today?
Your Honor, yes, you have our permission. Thank you.
All right. So I'll put via Zoom, signed by counsel. And Mr. Cornish, do I have your permission to sign via Zoom on behalf of your client?
Yes, Your Honor. On behalf of my client and I.
Okay, before I sign the documentation, bind over documentation, is there anything to be brought to the court's attention, Mr. Creno?
Nothing for the people, Your Honor.
Mr. Cornish?
Nothing from the defense today, Your Honor. Thank you.
All right, I will sign the bind over documentation. Mr. Labrie, this ends your time in district court. Your time in district court is over. You'll get your next date in circuit court where the case is going to continue, and you'll get that next date from Mr. Cornish. All right?
Right.
All right. Anything else for the record in docket 24-01532, Mr. Creno?
Your Honor, thank you. Nothing for the people.
Mr. Cornish?
Nothing from the defense, Your Honor. Thank you.
All right. Thank you for your appearance today. We're all set. Thank you for your appearance.
Thank you, Your Honor. Have a good day.
Thank you,
You
Judge.
too.
I'll see you later.
And then Mr. Labrie, you can tell them that you're all set in post 3, all right?
Okay. Yep. Okay.
No, you're fine right there. And I think, Megan, if you can, I think that's a device of rights.
Yes, Your Honor.
And that's windy and a little rickets back. All right, so we're on the record in docket 24-01518. That is People of the State of Michigan versus Rashad Walls. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Sarks.
Good afternoon, Your Honor. Jacob Starks, the fourth Assistant Public Defender here on behalf of Rashad Wallace. He's standing in my right at counsel.
And sir, you are Rashad Walls, is that correct?
Yes, Your Honor.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. It's my understanding this is going to be a plea to count 3 of the complaint. That's a count of a misdemeanor domestic violence, punishable by up to 93 days and or $500. There is no objection from the people to 7694A status if the defendant is eligible, and there is a sentencing agreement to no upfront jail, no further upfront jail.
So Killebrew agreement to no objection to 7694A status if eligible, and then a Killebrew agreement to no further upfront jail.
Correct.
Is that your understanding, Mr. Sarks?
That's correct, Your Honor, and defense counsel will file a written petition if he's eligible. Let's double check his criminal history.
All right, Mr. Sarks may inquire of your client of his advice of rights that you've offered to the court. So I'll just go over the main ones. May I inquire your clients of his misdemeanor rights?
Thank you, Your Honor. Yes.
Mr. Walls, you've signed an advice of rights and plea form indicating all of your rights in the matter. That's 1 through 12, and you've signed this documentation. Is that correct?
Sure, Your Honor.
So I'll just go through the main rights. You understand you have a right to be tried by a jury. You have a right to be presumed innocent until proven guilty. You have a right to be represented by counsel, and you are represented today by Attorney Jacob Sarks. He would be present to cross-examine any witness or contest any charges brought against you by the people of the state of Michigan. You understand that, sir? You also have the right to choose to testify at trial if you wish to. If your plea is accepted, you'll give it the claim the plea was a result of any promises other than what's been stated on the record or threats that was not your choice to plead guilty. You'll also be giving up the rights to appeal any issues from trial. Since you won't be having a trial, you'll be pleading to count 3, which is the domestic assault statute. You understand that, sir? Is that a yes, sir?
Sure, Your Honor.
All right. With that understanding, the plea has been indicated for the record. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right. I'm going to bring your attention back to May 20th of 2024 at the offense location of 829 Everett Drive in the city of Lansing, Ingham County. Were you present at 829 Everett Drive in the city of Lansing in Ingham County on May 20th, 2024?
Yes.
And who is Shanice Robinson to you?
The mother of my kids.
Okay. And you are pleading guilty today to the domestic violence count 3, which is that you offensively touched Shanice Robinson in some way on that date and time. Mr. Sarch, would you like to inquire of your client for the factual basis?
Thank you, Your Honor. Mr. Walls, back on May 20th, 2024, were you at the location 829 Everett Drive in the city of Lansing in Ingham County in the state of Michigan?
Yes.
And Ms. Robinson was at that location?
Yes.
And you have multiple children with Ms. Robinson?
Yes.
And at some point during that day, the two of you got into a verbal argument at that residence, correct?
Yes.
And the verbal argument escalated, and at one point you shoved her, correct?
Yes.
And you shoved her without her permission and without her consent, right?
Yes.
And that push was not done in self-defense, correct?
No.
All right, it was not done in self-defense, correct?
Yes.
Yeah, no, that's okay.
All right.
Thank you, Your Honor.
So, Ms. Wilson, anything towards the factual basis?
People are satisfied.
All right. I find this factual basis to be knowing, voluntarily, and accurately made concerning the factual basis for count 3. Counts 1 and 2 will be dismissed upon successful sentencing. So I'm going to have this referred to probation for twofold. One is for them to, of course, do a report. The other one is to check on the 6940 status that you're making application for. And then your attorney will file a motion in that regard once there's once there's been some determination made. So we'll refer to probation. That's on the 5th floor of this building. If you go down there, they'll either see you now or they'll set up an appointment. But what they'll do is they'll create a report for myself and we'll see what options are available to us at sentencing. All right, sir? All right. So sentencing date of
September 26th at 9:30.
September 26th at 9:30. Does that work for your schedule, Mr. Sarts?
I believe so, Your Honor, yes.
So we'll set it for September 26th at 9:30. I'll wait for a report to be done. Anything else for the record in 24-01518, Ms. Wilson?
No, thank you.
Mr. Sarts?
No, thank you, Your Honor.
All right, Mr. Wells, we'll see you on that September 26th day.
That's 9:30, right, Judge?
Correct.
Okay, thank you.
And if I could just have a second.
Yeah.
Thank you.
Fine.
I didn't, so the department may have their free trial.
The only thing that's coming up is I did like the ready for hearing thing, but none of the hearing jackets have talked about.
So then we have to do that.
But I did like the ready for whatever, scheduled it, but it's not coming up. I'm only seeing Judge Simmons stuff.
Did you change it to our stuff?
I like when I go to do like hearing officer or whatever the judge thing says, only she comes up.
Did you shut your computer down, Leslie?
I restarted it.
Okay, just a second.
Did you shut your computer down last night? Means it's not your fault.
Typically, the
Yeah.
Mondays just never wants to work.
It's glitchy.
I'll have to reset.
That's how it was explained to me was when I talked about it, it's glitchy. Which is another way of saying it doesn't always do what you want it to do.
This is the second time it's downloaded the same thing for me, so.
Hello? Were you waiting for someone?
No, no, we were not. We're in the middle of a hearing, a preliminary
Okay, I'm
examination.
sorry. Okay,
Oh,
sorry about
so,
that.
but we're all set. Thank you.
Okay, all right, thank you, sorry.